Good afternoon, Mr. Hussein. Can you
Yeah,
hear me?
good evening. I can hear you, Bavaria.
Okay, good afternoon.
Yeah, how are you doing?
All right, how about you?
I'm good.
Think you are good. Okay, good afternoon, everybody. Please, can you hear me? Please let me confirm that.
Yes, we can hear you.
Yes, we
Good
can hear you.
afternoon.
Good
Okay, good
afternoon.
afternoon, everybody. I welcome us to today's section of JIIPCC program. My name is Babalola Iyelelifemi Abdulmajid. I am a legal practitioner based in Ibadan, or let's say practicing in Ibadan. I'm a fellow enthusiast or legal practitioner with interest in intellectual property, sports law, and compliance regulatory advisory. So once again, I welcome us today, and I look forward to an engaging moment with everyone here. The mentees, good afternoon. I hope it has been going on well. I hope you have been enjoying the mentorship. I was once a mentee too, and I can assure you it was a great moment. It was a beneficiary moment and a memorable moment for me in my career. So I hope you get the best of it too. And to our mentors, thank you for the great work that you have been doing in improving us. It's really worth it, and it shouldn't be underlooked. So yes, I think we are. I don't know how many of us are the mentees. Well, I believe others that are not here will join us there. It's already 4:01 as we plan. Exactly. So please let's shoot on. About the program, let me just tell us about the few brief about the program. I hope we all know it about the program before, but just to remind us what the program is all about. Okay, JIPCC, in short, Juliana Imam Intellectual Property Corrective Consult, Intellectual Property Mentorship, and Internship Program is a quarterly program for students and young professionals across Africa. Mentees in the program are afforded the opportunity to access valuable advice, training, network, mentorship, internship discussion forums, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous training, development, and evolution in Africa and around the world. Well, I think the key word there is continuous training. There is this word that knowledge is continuous. Don't stop learning. Well, you can watch our videos by searching for JIPCC on YouTube and Facebook. And also you can use the hashtag #JIIPCCMIP. So I think it's simple. Just search for JIIPCC on YouTube. The same thing on Facebook. And then just use that, or using the hashtag, you get what you want. Well, on the objective of the program is basically meant to provide easy access to quality professional graduates, training, and resource materials for students and young professionals in Africa, as I said earlier, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation, to facilitate further mentorship, internships, scholarships, and job placement for the mentees. Sincerely, that last objective, I can tell you that while I was doing my own mentorship, or while I was under the mentorship scheme, using under the platform of the mentorship, I had my first basic job on intellectual property. I just on the platform, just one day, Juliana Imam, she posted the job on the WhatsApp group of I think research assistant on IP with Rita and Weary. I hope all of us know, most of us should know Rita and Weary. So, and luckily for me, I was able to get it. I got the first major job on IP on the platform. So yes, it is not a mere thing, it is what you can get. So what is it about the objective? I hope we get the best from it. Yes, before we proceed to the main program for today, to our presentations, there are a few announcements that we love to make. One is that the registration. Yes, I said earlier that the mentorship program is a quarterly program. So yes, you're already preparing for next year. So the first quarter for 2023 mentorship session is already ongoing. Yes, the mentorship program is already ongoing. You can see the link online. Basically, it's not just on IP, it also covers artificial intelligence and technology, that's AI. It covers mentorship on energy industry, fintech, health tech and law, patent drafting. So yes, you may also have interest in other fields and not just this. You can also invite your friends, send to your friends, inform your friends who can be interested to apply for it. So that is it about the next one towards 2023. It's already ongoing. Share the links, inform your friends, and you can apply too for the other ones that you have not done. And yes, the mentorship, there is also an option of 30 minutes of private mentorship. Apart from this, there's also a platform for 30 minutes private mentorship with mentors. So yes, except apart from this general one, you can also have an avenue to have a private mentorship with our mentors, experienced mentors. So also, yes, you can see it too. 30 minutes on one-on-one mentorship with our favorite JIPCC mentors. So I don't know, maybe we try and post the links on the charts, but you can see it on the screen too now. Also, you are encouraged exactly. So as we are going on, please let us put on our videos. You can see me. Can you see me? Oh my God. Okay, I think I'm also saying this to myself too. Sorry. Okay, I think I'm having issues with my laptop. Oh God. Let me see if I can join with my phone. I'm having issues with my laptop. Apologies. But please, let us try and put on our videos. Let's know each other. When you see the face, it impacts more than just seeing than just hearing the voice. So please, let's put on our videos, so we can enjoy it more. I will try and see if I can join, if we can on my video somehow too. I will try and work on that too. So and yes, you should know that we are streaming live. So let the world see your face and not just your name. Basically, we are live, not just on this Zoom. It is also showing live on YouTube. It's showing live on YouTube now. So please, on your video, let the world see you, basically. And then yes, as you can see, my name is fully here. If you have a like yearly. So please try and edit your name. You can actually just go to your menu and make sure your name is showing your full name. Your full name. This is my own full name now. If you have a like yearly, you can see okay, I can see Philip Inwozu. I can see Amarachi Kiariavo. Just try and edit your details to show your full name. What says? And yes, for everyone, everyone here, we are planning. There will be an end of year party. Yes, JIIPCC end of year party, which will be holding in both Lagos and Abuja for those that are staying there, for both mentees and our mentors, to have a face-to-face, like just have a kind of how would I call it, meditation on the year we have gone, and then the kind of looking towards our goals for the new year. So it's basically end of the year gets together, both in Lagos and Abuja. Anticipate and register. You can register too. Please let us work towards it. All groups are encouraged. Okay, yes. The last thing before I move to the normal program is the week 8 awareness project. Is that a screen for that? The week 8 awareness progress. I believe the mentees are aware of that. The awareness project that is going to be happening by week 8. Please, all groups, we are encouraged to start working towards it. Week 8 awareness project. Mentees, I believe you are aware of it. So please try and start working towards it. So it won't choke. So please, the earlier you start to prepare, the better it is. And yes, let me introduce you to our mentors for today. The people we are here to talk for their experience and knowledge. Okay, let me start with exactly. So the first our mentor is Amusa Shukrat Modipiola. Sincerely, I
We can't hear you, Babalola. Are you with us? Can anybody hear him? I can't hear him.
No, I can't hear him as well. I think his network is having issues.
Okay, so I'll be reading our mentor's profile until he joins us to continue. So our first mentor for today is Miss Amusa Shukrat Modupeola. Amusa Shukrat Modupeola is a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She is a member of the World Intellectual Property Organization, WIPO, committee and has a master's degree in intellectual property at African University, Zimbabwe, in conjunction with WIPO and Japan government. She has partaken in professional training at the World WIPO as well as other IP related bodies and has facilitated numerous intellectual property related programs both online and offline. Shukrat is the pioneer of an educational platform, DIN, the Intangible Nuggets, which facilitates IP awareness and brings the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and registered them for WIPO advanced courses. Amosa is an accredited agent in the Nigeria Intellectual Property Office, Nigeria Copyright Commission, Trademark, Patent and Design Registry, and her expertise are both, but not limited to trademark, patent, industry design, copyright, trade secrets, respectively. Thank you for being our mentor today and choosing to mentor the next generation, Isamosa Shukrat Mupe. So our second mentor for today is Ms. Juliana Imam, co-founder of
okay, apologies.
Gypsy. Sorry. Okay, are you with us now? Can you hear me?
Yes,
Okay, so you can continue reading Ms.
I'm
Juliana.
back. I'm back. I apologize. Yeah, my network tripped over a moment. Okay. Thank you for assisting me, Mr. Hussein. So yes, our second mentor for today is our well-known Juliana Imam, Juliana Uwajimam Ubujuse, also known, I hope I'm correct with that pronunciation, also known as Juliana Imam. She's an entertainment and intellectual property lawyer. She's the founder of JIPCC, a Global Sherpa alumni and a WIPR leader for 2021-2022. Yes. She's actually doesn't need introduction, but we have to do it for formality. So yes, that's about I can assure you we are going to gain a lot from them today. So that's our mentors. I hope we meet them. So yes, for the group presentation, each group will have 8 minutes to give us a presentation. So each group has 8 minutes. So please let us try and work with the time while presenting. So group or mentee, I wish you all a good presentation ahead. So yes, group 1, please, are you available? You are good to go now. Okay. Group 1, is anyone from group 1?
Yes.
Okay. Okay, you can start now. Please, you can start now. Are you the one presenting?
Yes.
Okay, you can start now. You have the floor. Sorry, who is sharing the slide for you? Okay.
I'm the one. Good evening, everyone.
Yeah, good evening. You can hear
Yeah.
you.
Good evening. Can hear you.
Okay. Please, can you see my screen?
Yes, we can.
Okay. Good evening, everyone. My name is Temitope Folayan. I'm from Group 1. I'll be speaking on IP protection for creative. Intellectual property plays a vital role in the film industry. The film industry are protected by copyright, trademark, and patents. Without this important protection in place, artists, writers, and other creatives won't be able to profit from their work. When you own a copyright, you have the exclusive right to when you own a copyright, you have the exclusive right to make copies and distribute your work, to perform and display it, to create derivative work from the original work. Copyright makes it possible to create licensing deals. Producer can also negotiate various agreements from IP rights. Film industry can also be protected with trademark. Trademark establish and protect a movie brand. It also protects source of financing. It protects film merchandise. A patent also, a patented invention during filmmaking can also be protected. Cases of people who gain revenue as a result of protecting their film, and a case of people who suffered loss as a result of not protecting their film. We have Titanic. Titanic earned $1.2 billion from video and DVD sales and rentals, in addition to the $2.2 billion it's grossed in theaters. We have the loss. In 2010, the Hollywood box office, it's like others, suffered 16.5 million illegal download. Okay, I'll move to the next one, which is dance. A basic dance cannot be protected, but a choreography can. However, there are guidelines to follow before a dance can be copyrighted. They are originality, fixation, expression, functionality of protecting their dance. In 2011, they in 2011, they claimed Beyonce in a music video Countdown used it without giving her credit, and she received an amount for damages. A case of people that suffered loss as a result of not protecting their dance, that did not give credit, but it was not copyrighted. That was why they were not awarded any damages. We also have the trademark. A fashion can be protected through trademark. Example of trademarked fashion brands are Chanel, Gucci. Trademark protects brands against counterfeit and knockoff. However, protection under copyright is not available where a designer intends to make mass production for commercial purposes. Patentable inventions are protected. Patent only protects the invention and not the design. A case where people that gain revenue for protecting their fashion design. We have Yves Saint Laurent gained 2.5 billion euros. A case of people that lost revenue for not protecting their brand. We have Don Omol Engine, who was denied copyright for the fabric pattern because it was not an original pattern. So I move to visual arts can be protected by trademark, copyright, and patent. Visual arts are creation of visual works such as drawing, painting, photographs, or printmaking. Copyrights protect visual art. For a visual art to be protected, it needs to put in some fixed medium, paper, or film. The owner of the copyright is the author. There is an exception to this above rule. The exception is where an employer owns the copyright of the creation of the employee. The owner of the copyright has exclusive rights to prevent or allow others from copying the work, performing the work, make the work available to the public. We have trademark. A visual art can be commissioned to create trademark. A commissioned visual art is advised to do a pre-trademark search to ensure that his ideas are not registered. A visual art can also design a trademark to protect its brand. We have patents. If a patent is technically inventive and innovatively functional, it may qualify for a patent. Literal work can be protected through copyright. Copyright Act of 2004 regulates the protection of intellectual property contained in literal work, among others. Copyright in literal work lasts for the lifetime of the author and 70 years after. This can be renewed afterward. Conditions for protection of copyright in literal works are originality, fixation, and registration. Advantage of registration are: it serves as proof of original work. A suit for infringement can be filed when the copyright is registered. A registered work is less likely to be copied than an unregistered work. Example of people who gain revenue as a result of not registering is literal work. We have J.D. Salenga, the author of The Catches in the Rail, made financial gain from an infringement suit which he filed against a Swedish author for releasing a book whose storyline and character were similar with the storyline and character of his book. Example of person who lost revenue as a result of not registering is literal work. We have Paul Allen claimed infringement of creative work against a Nigerian brewery. The court struck out the case on the ground that the plaintiff has not provided a proof of registration of the work. Music is protected through copyright. Copyright law defines the rights conferred on author of original works and those who perform them, as well as those who support their widespread dissemination. A copyrighted music enables the owner to reproduce the music, distribute the music, broadcast the music, adapt the music. How related rights can be used? Performers benefiting from related rights can authorize or stop others from recording or broadcasting their live performance, or otherwise distribute, broadcast, make available, or communicate to the public their recorded performance. Producer of phonograms those responsible for the fixation of work, such as its recording, also enjoy related rights, whereby they can authorize or block the reproduction, importation, and distribution of their phonograms or record CDs, etc.
Temitope, you have 1 minute more. Temitope, you have 1 minute more.
Okay, I'm almost through. Case of people who gained revenue for protecting their music and case of people who lost revenue for not performing their music. For the revenue, we have Led Zeppelin, who secured a legal victory in one of the longest running copyright lawsuits in music industry. Thank you.
Thank you very much, Temitope. Group 1, thank you very much, everyone in Group 1. That was a nice presentation. So yes, let's move to the next group. Group 2. Group 2, please, are you available? Group 2. Please, anyone from Group 2?
The presenter for Group 2 can unmute yourself, or the backup presenter can start the presentation.
Okay, if there's no one, let's Group 3 then. We can move on with another group and then we can come back to them.
Group 2.
Group 2, okay. You are welcome. So your time starts now then.
Okay, good evening, everyone.
Good evening, good evening. The time has started though. Valerie, the time is running already.
I see my screen.
Yes, you can see your screen now. You can start.
Okay, sorry, I was trying to.
You are almost seeing. Okay, yes, you're all right now. You're all right now. You can start now. You can see your slide now. Yes. Yeah. Can someone else from the group share the screen for her? Can leave it like that. Oh no.
I need difficult to turn on my. Is my video on?
You don't need to.
Okay,
You don't need to
leave it
turn
like
off
that.
your
Leave it
video.
like that. Just leave it like that.
Continue.
I'll stop presenting. Leave it
Okay.
like that. Yes.
Good evening, everyone. My name is Chisimdi Valerie, and I'll be presenting for Group 2 on the topic Intellectual Property for Creatives relating to comedy, broadcast, and software programs. So my presentation will cover the following subtopics. 1, intellectual property for creatives. 2, importance of contracts and contract review for creatives. 3, clauses to look out for when entering into a contract. And finally, cases of people who have gained revenue or lost revenue as a result of paying or not paying attention to details in a contract. So I'll start by defining a creative. A creative refers to a person who has the ability to create through originality of thought or imagination. Now, from this definition, I'd like us to understand that a creative is an intellectual who engages in critical thinking and research to produce original results. So the key word here is original. The creative's work has to be an intangible creation, and intellectual property laws are laws that exist to ensure the protection of the works of a creative person and enable people gain recognition of financial benefits from their creations or inventions. Patents, trademarks, copyrights, and trade secrets are different types of intellectual property rights under which a creative can be protected. So now let's look at software programs. Software programmers basically work on the development of computer software by writing codes and programs needed to perform specific functions. Section 39 of the Nigerian Copyright Act recognizes computer programs as part of literary works registrable under the Act and provides for copyright protection of these programs. However, under trademark, what can be protected are software titles such as brand name, brand logo, color, and slang. The software itself cannot be protected through trademark protection. So it's important to note this. So for any software program to be protected under either patent, trademark, or copyright, it must be an original invention or an improvement upon an original invention. So these requirements must be fulfilled. So I'll move to the next slide now, which is broadcast. So broadcast, it involves the electronic dissemination of information, signals, audio or video content, etc., to a vast group of people who receive the information either through television, radio, newspapers, magazine, or other digital platforms. Section 1, Sub 1 of the Copyright Act 2004 lists broadcast as one of the works eligible for protection. Also, the related rights protection associated with copyrighted works protects broadcast in Nigeria. So the next is comedy. Comedy is a very popular form of entertainment. So it simply means amusing entertainment through original, creative, and innovative thinking. So it has to be original. So a comedy, being a literary work, is protected under Section 39 of the Nigerian Copyright Act. Section 1, Sub 2, Paragraph A of the Nigerian Copyright Act provides that for a comedy to enjoy copyright protection, it must be an original work created through sufficient effort. So now let's look at the importance of contracts and contract review for creatives. For a person in the creative industry who is obviously working with different clients, it's very important and essential that they enter into the right contracts to protect their original creations. Just like every other contract, a creative contract is a legal binding agreement which protects the creative and his work. So now, why is it important for a creative to enter into a contract? A contract is useful for numerous reasons. Firstly, the parties are able to clarify and agree on what is expected from both sides from the onset of the contract to prevent future misunderstandings. So this means that from the beginning of the project, the parties understand their expectations and boundaries. So secondly, contracts are essential in protecting the creative's work from being used in the wrong way. It ensures the creative gets paid at the agreed time. It makes communication easier. It makes performance faster. Then for a good contract should contain dispute resolution methods. So in event of a dispute, the contract will stipulate what form of dispute resolution method the parties will embark on. So now, what clauses should one look out for when reviewing a contract? So the clauses in a contract are specific provisions that relate to an important point of understanding between parties engaged in a legal agreement. So the following are clauses to look out for. A contract clause should include a contract should include a clause which provides a good description of the work and services and allows for changes and revisions to be made to the contract. A good contract should also contain an additional charges clause. So this means that it should provide for rates to be charged for additional edits and revisions to the contract. We also have breach and cancellation clauses. So this includes the option to terminate the contract. Now we understand that a creative's business is completely built around intellectual property. And so the intellectual property clause is also very important. So this clause will provide for the right of ownership even after the termination of the project. So now, and that clause to include is the indemnity clause. So the indemnity clause provides for who will be held responsible if something goes wrong during the course of the project. We also have general clauses, and these are just important. It's important to include the general clause for any additional items or statements to be added to the contract. Now let's go to the next slide, which contains the reference cases of people who gained revenue as a result of paying attention to details in contracts. So we have the case of Brown and Goldstein. So the summary of this case is just that the plaintiffs filed a suit for breach of contract, alleging that their music publisher failed to pay them money from public performances of the band's song. So the Court of Appeal held that the language of the agreement demonstrated that the contract was reasonably susceptible to the plaintiff's proposed interpretation. Now, cases of people who lost revenue as a result of not paying attention to the details in contracts. We have the case of Bartlett Grain Company and Shader. So the summary of the facts of this case is that the plaintiff, who was a grain company, entered into a contract with a clause stating that any disputes regarding the agreement would be arbitrated and the arbitration award binding on the parties. Later, dispute arose and judgment was entered against the defendants. The defendants went ahead to resist the award. So the court rejected the defendant's argument that the arbitration clause was unconscionable and held that the courts will always uphold terms agreed to in written signed contracts. So this case goes ahead to show the importance of going through clauses in a contract, in a contractual agreement. So other cases include the case of NM Chukwu and Okoye and Morka Finance, and the case of a Google AdSense publisher, Dylan Writer. So with this, we've come to the end of my presentation. Thank you very much for listening.
Yes, Valeria. Oh, 2 minutes more.
Okay, so please let's hear from group 3. Thank you.
Group 3, please. Group 3.
If group 3 is not ready, group 4 can start presentation, then we'll come back to group 3. Presenter for group 4, please. Are you with us? Presenter for group 4, please, you can unmute yourself, or the backup presenter can also step in. And if group 3 presenter is with us, you can present, or your backup presenter can also assist you. Any member from group 3 or group 4 can present, please. Okay, while we are waiting for group 3 and group 4, I think we can call on our mentors to give us their comments and review now. I think group 3 and group 4 are not available yet. So the first mentor today, Ms. Amosa Shukrat, you can start. Sorry, can you all hear me?
Yes, I can hear you.
Yes, we can hear you.
Okay, so I don't know if Amosa is here, but if she's not here, I'll just go ahead to make the comments.
Can you hear me?
Okay, yes, I can hear you.
Okay. Let me try to turn on my video. Okay. I hope it's not too dark. Okay, good afternoon, everyone. So I listened to the presentation. Well done to the mentees. You guys keep improving all the time. So I'm just going to address group 1 and group 1, yes. So they're talking about how patents relate to the film industry, but I didn't quite get any relation. with patent and the film industry, because majorly patent is about invention and the film industry is more about creativity and not invention. So they don't do more of invention. So let's assume before they do their production, they kind of come about an invention which they can patent. Then fine, we can now relate patent to the film industry. But so far so good. They really don't do more of inventions. It's just creativity, which has to do with copyright and maybe trademark. Then the next one, she mentioned that copyright, you have to register your copyright for you to be able to seek for damages. Actually, that's not actually true. You can actually seek for damages even if you don't have your copyright registered. But copyright registration is for your own advantage. So you really don't have to go and look for proof somewhere you didn't keep the proof. So if you have the NCC notified about your copyright, then it is better for them to just when they give you your certificate, you can show it in the court and say, okay, I have a certificate, unlike when you didn't register. However, in the US, you have to register your copyright before you can actually seek for damages. So it's quite different from our own law in Nigeria. You can seek for damages without registering your copyright. So I just said I should clear that. Then I think that's all from what I picked from the speakers. Yes. Thank you.
Okay. Thank you very much, Amosa, for your comments. It's always good to have you with us. So I don't know if Group 3 and Group 4 are ready to make their presentations, but so I'll just comment on Group 1 and Group 2's presentation. I think that you people did an amazing work researching and also presenting. I think that you did a very good work. One of the things that you said, that's for the group that spoke about copyright. You spoke about renewing your copyright registration and all those kind of things. So let me just clarify. For the different copyright registrations, there are different time frames that it lasts for. So some last for 50 years, like a sound recording now, that lasts for 50 years, while for some, they last for the lifetime of the author and 70 years after. After that duration, it goes into public domain. So there's nothing like renewing your copyright. What people renew is trademark. So depending on the jurisdictions, there are some that you have to renew after 10 years. There are some that you have to renew after 7 years, like in Nigeria. So it depends on the jurisdiction where you are. Then let me just state that if you want to be like an IP professional that is for like creatives and the inventors, it's good that you try to understand all these concepts, because when a client comes to you, they might not really say, okay, what I want is a trademark, what I want is a copyright. They might just come and tell you a long story. So you're the one that would then say, okay, from all the things that you shared, this is exactly what you need. Trademark, copyright, etc. So I would like to encourage everyone here. Rome was not built in a day. So having this session is not even enough to cover you on all fronts. But aside from this, try to listen to a lot of videos online that has to do with like the creative industry. Then try to read different articles on it. Then join programs like this. And then if you can attach yourself to a firm where you do like live cases, that would also be very good. So for me, what I try to focus on is like the music industry. So I try to understand everything that goes on in the music industry, from the creative side to the business side to the legal side. So try to think about where you might want to fit in and try to understand the process of it so that you can advise your clients properly. So if you want to go into the film side, then try to understand the process for the film industry and how it flows from the beginning to the end, so that if they come to you with a particular part, you can easily advise from that angle. But it's always good to know the business side of wherever you want to focus on. So I'm just trying to talk about it like from a practical practitioner's point of view. For some people, you might have the privilege to actually work with a law firm that practices this daily, but for some others, you might not have that advantage. So if you don't have that advantage, what you can do is to study a lot of it online and then post about it online a lot, so that once people have that issue, the first name that comes to their mind is your name. So for example, when I first started my practice, I posted a lot about the things that I wanted, and gradually when people needed those services, they reached out to me because like I was top on their mind. Same with Amosa. If you should go to her page, if you just go online, you don't even need to, once you type anything IP and you put the hashtag, her work must come up. She's not a fool for doing that. She's actually leaving her digital footprints online, so that once somebody needs that service, whether they've been seeing her, whether they are from her region or not, once you search online, you just find her, and that's how people got to know her. So if you have decided that, okay, this is exactly what I want to do, you might not know everything, but just start talking about it. And then if somebody comes to you, then the person says a lot of things, you can then pick out what they need. After you know what they need, if it's now a copyright, a trademark or whatever, if you're not too sure, you can then reach out to a senior colleague to actually explain it better to you and put you through. So I will stop here, but I think that the two presentations that we had are really good. Some of the areas are novel, like the dance, and for the comedy too, it's something that not a lot of people have actually ventured into, but it's good that you understand all these concepts, so that whenever anybody should reach out to you, you can easily know what to say. So well done, everyone.
So I would like to say one or two things. So I think it is important that we know that intellectual property is not entertainment law. Like, people really don't know the difference between IP and entertainment law. When you say entertainment law encompasses IP, it encompasses contract, business registration, it's everything in full. So IP is just a subset of entertainment law. So I think General Imam focuses more on entertainment law, but I don't do entertainment law. But because IP is an aspect of entertainment law, I need to know IP and how it relates to entertainment law. So I do intellectual property generally, trademark, copyright, patents. But if you know you don't have that capacity to do all, just you can specialize on just one. Like we have Akinyemi Law. Akinyemi Law specializes on music. Anything music, just go to him. We have my lawyer Sabi. My lawyer Sabi specializes more on trademark. Anything trademark, you go to her. So if you can't do all IP aspects, just specialize in one. Because me, I'm more like teaching and education. I can't teach patents and not talk about trademark. I can't take trademark and talk about copyright. So I do all. But if you know you can't do all, just I think there are different courses you can take. Paid courses, free courses. You have to join IP communities. There's GIPC, there's my IP Law Guide, there's IP Radio. I think there's one now, Nigerian Intellectual Property Community Club, right? And NIPC. There's that too. I have DIN community, the Tanzania community. So there are different platforms you can join. Except you are not ready. As long as you can buy data, you will always get something. And another thing is the fact that you are doing this, it shows that you want to start something. So don't get this knowledge and sit down at home or sit down on it. Yes, you might not be sure of what you are doing, but when you post it and somebody sees that, oh, you're actually wrong somewhere, they'll come and correct you. But when you don't put it outside, nobody will even know if you are doing the right thing or you are doing the wrong thing. So we should be open to criticism. From there, you grow and you know whatever it is you are doing. Another thing is, don't have the mindset of, I want to make money. because the money will not come. The money does not come right after. Social property is still very new in Nigeria. So to make money is hard. Even we are not making money. And that's, people don't know. We do all this program, you see, this person is invited for this program. They are all free programs. They are not paying you anything. It's just services. It's just that once you do it, people get to see that, oh, I saw this person somewhere. I saw this person somewhere. That means this person knows, this person might know this. And sometimes you're like, okay, I don't want to give anybody free discovery call. Or most people don't know IP. So you have to be ready to invest. If I have someone that is asking me for something, I'm like, no, you have to book a discovery call of 10,000 naira. If I said no, then there's nothing to teach. But if I give you small tips about what you're meant to know, and I say, okay, if you want to know more, then pay for a discovery call. At least you are convinced to some extent that, oh, this person can actually solve my problem. But you don't even know what I have to offer, and you're immediately asking for money. So everything is not about money. You might not make money immediately, but people are seeing what you are doing. And that's just it. People are seeing what you are doing. You'll be surprised that when you reach out to me, like, oh, I've seen your work somewhere and I have that intention to reach out to you. People are seeing it. Just do the best you can do. Like I said, you don't have to know everything. You can just specialize. We don't know everything. That's just, we don't know everything. IP is very complicated when it comes to copyright. This one is coming up today, this one is coming up tomorrow, but just try your best and read. You have to read. It's important to read. You might just read case studies. Like me, myself, I really don't read IP like that, but I read more of case study. So when I read a case study, I get to learn new things about that case study. Then I can apply it to another case study. Then I get to learn something new from that case study as well. So just read IP, publications, infringement cases, and all of that. Thank you.
Thank you, Amusa. Thank you very much. We really appreciate it. That reminds me of a question that pops up on the group I belong to. IP, basically entertainment lawyers in Port Harcourt, just a group of lawyers on entertainment law in Port Harcourt. So there was a question that popped up that said, which one is more brother? Like, which one is brother? IP or entertainment law? It was a discussion on the group like that night.
Okay.
Trying to say it is IP, it is entertainment law. So I think, well, just it's a question we can discuss later. That which one is brother? Should we say IP?
I think IP is broad because if you are doing entertainment law, you don't need to know all the aspects of IP. You don't have anything to do with GI. You don't have anything to do with traditional knowledge. You just need to know copyright. Just focus on copyright and trademark, and you are good to go. But if you are doing IP majorly, like you have to know trademark, patent, you must be able to draft patents, draft your claims, GI, traditional knowledge, genetics. Like IP is very broad on its own. So when you are doing entertainment law, it's just a part of IP that you need. Yeah.
Thank you very much. Please let's quickly address group 3 and 4. Please, group 3, can you come in now? Group 3, please, anyone from group 3. You can see some more. Daylight Shidi, group 3. In what for? Please, are you guys ready? Group 3, what for Genevieve? Okay, Fatima Mohammed, group 3. Please, anyone from group 4 then? Group 4, Kristen. Please, can you? Group 4, Kristen. Please, group 4. I can see Ola Alice Oyukashola from group 4. I believe you have something to present for us. Please, we are waiting for you.
I don't know why they are not replying, but I'll be calling the group leaders to step in now. So the group leader for group 3 is Adeyanju Olalekan. Adeyanju Olalekan, are you with us on this meeting? You will have to present for your group because you are the group leader. You are supposed to organize your group, coordinate your group, and make sure everything is going fine. So we need your group right now to present for us. Adeyanju Olalekan, are you with us in this meeting? Our group leader for group 4 is also Mbana So Victoria. Mbana So Victoria, if she's with us, you can present for group 4.
Group 4. Please group 4. I can see
I
Kehinde,
think I can see
Anishilowo.
Mbana so Victoria with us.
Fatima Emisu. Are you in group 4 too? Group 3.
Okay, so that we don't take too much time, it's good for us to know that the way this program is structured is for everybody to do their research and to present so that we can touch the different areas and you have an idea about it. So group 1 and 2, 3 and 4, we're supposed to talk about those that innovate in IP. So if we don't have presentations for group 3 and 4, that means we will not be touching the innovative side of IP. And I want to tell you that that is a huge disservice to yourself, because at the end, inventors will come to you and you might not know the solution, but that's fine. So since we're done with listening to group 1 and 2, I think that we should go for the picture time, and then we take the questions for those who are interested in knowing more. Thank you so much. So please, let's put our videos on. Please put your videos on. Make sure you smile. Good to see you, Junior. Good to see you, Rachel. Kulthum, Musa, Mahmoud, Aisha. Please be taking your screenshots. Abimbola Subola, I'm always seeing you on LinkedIn. Well done. Tijani Salahuddin, okay, your video is not on. Nifemi, good to see your face again. Amarachi, Oyewumi, Mariam. Hi. Ife Chumelu, 114. We have a lot of fine ladies here. Chisimdi, hi. Alice, good to see your face. Mbana, so Victoria, hello. Doing Sola, hi. So please, let's just take a screenshot. Sorry, I'm using my phone, so if I missed your pictures or something, please don't be angry. So if we've taken the pictures, please feel free to post about it on LinkedIn. As been said, okay, yes, okay. So let's ask our questions. If you have any question, please just raise your hand up, and we'll take your question, live questions, before we then ask the questions that were present. So if you have a question, please just raise your hand up, and Nifemi will call you so that you can ask your question.
Yes. Please raise your hand if you have a question. Seems there is no. Please, any live question?
Any live question on the creative side of IP? Any live question for me or for Amosa?
Okay. Group 4 presenter is there. Should we?
Yes, you can ask them.
I think group 4 presenter is here. So the presenter is around available now. We still have time for them to present.
Yes, the person can present.
Okay, group 4. Can go ahead with your presentation. Group 4 presenter.
Okay.
Victoria,
I think
Chinyaka, are you available?
Sorry, Nifemi, because I think you can ask the questions so that.
Sorry, Ma, the group 4 presenter is ready, but I don't know, he's having issues with speaking up.
Well, since he's having issues speaking up, maybe he doesn't want to present. So I don't know if there's a backup presenter that can present on the group's behalf.
Good evening, everyone. I'm Oyomi Miriam from Group 4. I'm the backup presenter, so I'm going to
Your
present.
time starts now, then please.
Okay.
You can start immediately. If you are cool now.
Yeah, please, can you see my screen?
Yeah, we can.
Yes, we can see it. Oyewe.
Okay, so introduction. The medical. Okay, wait. First off, I'm going to talk on intellectual properties for inventors. How inventors in the medical and pharmaceutical industry use intellectual property, and also how inventors in the tech space use industry. Okay, talking on how the medical and pharmaceutical industry use intellectual property. I'm going to start with introduction. The medical field is undergoing significant changes at the turn of the decade. Genetic engineering, big data, and healthcare technology are all cornerstones of the next decade of the industry development. So given the amount of research directly affecting the healthcare sector, intellectual property law becomes a significant aspect. Patent is a huge aspect of biotech and medical research. However, other IP areas are also crucial in the business model of most medical related businesses. So a patent is usually a grant made by the relevant government authorities within a country to protect new inventions or improvements thereon that are considered to have improved the ways the earlier inventions are made or used. Patents help to prevent other companies from easily profiting from the inventor's creation, which will significantly reduce their profits and eliminate the incentive to innovate. Then, apart from patents, a patent is a way inventors can use IP to protect their invention in the medical industry. Apart from patents, another way inventors can use IP to protect their invention is through trade secrets. An example of trade secrets in the medical industry is drug screening procedures, which can be made of different processes. So instead of patenting these procedures, which will make the process vulnerable to others changing part of it to avoid infringement, the inventors can use trade secrets so long as the trade secret is known to a selected few. Then another way they use inventors in the medical industry use IP is through design patents. Design patents is another intellectual property right that applies to healthcare. Design patents protect the aesthetic and non-functional aspects of the product, like its texture or visual design. A friendly design element can contribute in small but significant ways to ease stress. So, criteria for the grant of a patent. The global standard for the grant of a patent is that the invention must be patentable. And an invention is patentable if one, it is new, that is, which results from inventive activity and it is capable of industrial application, or two, if it constitutes an improvement upon a patented invention and is also new and it results from inventive activity and is capable of industrial application. Inventors can use IP in different ways. How inventors in the tech space can use intellectual property. So inventors in the tech space can use intellectual property in different ways. For one, they can use it to enhance inventor business market value. So IP can generate income for tech businesses. For example, an inventor can license his or her IP and lend it to various businesses in exchange for a fixed income. An inventor can also reap benefits from selling IP products and services for a fixed amount of royalties. Then protection against destruction and infringement. So intellectual property provides an avenue opportunity and defenses against technology destruction and infringement. Then also, patents recognize and reward inventors for their commercially successful inventions. Also, for when a new technology comes into the market, the general public benefits from it. Another way inventors in Texas can use IP is that it helps patents in particular helps to stop third parties from relying on the efforts of the inventors. Then other intellectual properties that can be used to protect a new technology include copyright. This protects the artistic expressions of a creative. Then we have trademark. Trademarks are signs that distinguish a goods or service from one enterprise from the others. Then trade secrets also. Trade secrets can also protect inventors' rights in the tech space, whereby only the process of making the technology is known to only a selected few, and it is not known to the whole public. So yeah, that's all what we have. Yeah.
Okay, thank you. Oyewumi, yes. Thank you for the presentation. So now, as I asked earlier, can we go for live question now? At least we have the presentation. I believe it should give us more avenue to ask questions. Thank you once again to Group 4 presenter for Oyewumi for coming up as the backup presenter. Thank you very much. So yes, before I move to other question, is there any live question?
Okay, so maybe I'll just.
I believe there is no live question.
Okay, so maybe I'll just make a comment about the presentation. I think that the presentation was well done, and I want to talk about when you're listening to your client, and maybe your client is an inventor or maybe a creative, try to note that they would most likely need more than one of the IP protections. So it's good for you to have all of them at your fingertips. So somebody can come and you realize that the person needs a copyright, the person needs a trademark, the person needs a patent and all that. So you would then tell them, these are the different things that you need. And then some might have the funds to do all at once, some might not have. So you would then go ahead to advise them which is the most important. So for example, if someone is an inventor, they might need to use a trade secret, they might need to use a patent. So you need to then explain the pros and the cons for the two of them. For the trade secrets, that can be in perpetuity. However, it has to be kept a secret and it's not necessarily registrable. But for a patent, you can register it if you meet all the criteria, but you have to disclose it and it stays for just 20 years. So these are the things that you would explain to your clients. Then based on the things that you've explained, then your client will then tell you, okay, this is how I want to proceed. Then if it's a creative too, you can, it's good for you to also know the process about what they are doing and then know different things that they will need. So if it's an artist that's about to be signed to a record label, what are the kind of things that you advise the person? First of all, the person should send you the contract so that you can look through the terms and the conditions in the contract. Then you would also know, then you also advise the person to trademark their name if it's still available. Because now what some record labels do is that they'll just go ahead to trademark the name for the artist. And then if the artist wants to leave, the person will not have access to that name except they have to license it from them. So those are things that you have to check in the contract to understand, to be able to advise your clients properly. You also have to look at the ownership clause. Who would be the owner of the work? Whether it's an inventor or is a creative, who would actually be the owner of the work? You have to be sure about it. Then, so these are different things that you have to look at in the contract. Then even if it's for distribution, now there are some distribution companies that will put a clause that they would own the work. So as someone who is going through the contract, you should be able to point that out, that you don't need the ownership of this work for you to distribute it. You can distribute the work without taking ownership of it. So I think I would stop here. Thank you.
Thank you very much.
Okay. I'd like to add one or two things.
Okay.
I was going to say the same thing Juliana just mentioned. We have to take note of IP overlap. It's called intellectual property overlap. That is, a particular IP right might be overlapping with another IP right. So just like you mentioned, trade patents and trade secrets. So you have to look at the pro and cons, just like Juliana has mentioned. Why patents? Why trade secrets? Which one is preferable for your business? Look at the tenure. What's the duration? Are you looking at something that has a long duration or a shorter duration? If somebody comes back to reinvent the wheel, can they actually take you out of the market if you didn't patent your invention? So things like that should be looked into. And if it's on the creative side as well, you can also look at copyright and patents. There's an overlap in copyright and patent with regards to technology, computer software. Copyright and industrial design have an overlap as well. Trademark and industrial design, there's an overlap. Copyright and trademark has an overlap. So you have to look at which industry the person belongs to. The duration, what exactly do you want? What you are doing, is it for a longer term or a shorter term? Which IP right will actually protect your interest better? So for example, if you want to do like a software protection, so the software now, normally Nigeria protects software under copyright. So let's assume your software has a problem it is solving. Like we know, invention, your patent must be solving something. It does not have to be all wire electrons. It could be something as simple as putting a straw in a bottle of water. What is that solving? It's solving the problem of spillage. So as long as you are solving a solution, then that solution can be patented. So if maybe your technology is actually solving a solution, then you could either say, okay, fine, I'll go for copyright and also go for patents. So in that, you have two different protections. You have the patent protection for the technical aspect and the copyright protection for the literary aspect, because your codes 0 and 1, they'll be in literary aspect, not artistic now, they'll be in literary. So that will be for copyright. So if it's for trademark, probably you have a bottle, just like Coca-Cola, and you want to trademark that bottle. Although we know industrial design also protects shapes. You'll be like, okay, fine, industrial design will last me for max 15 years, 25 years. Why trademark can last me till eternity? So which one do I want to go for? Do I do industrial design or I do trademark? So now let's assume Coca-Cola did industrial design. I mean, their Coca-Cola bottle will be everywhere by now. But because they chose to do trademark, they still have that protection over their trademark. The same goes for their recipe. If Coca-Cola had actually done patent instead of trade secrets, their recipe will be out by now as well. Coca-Cola stick with trade secrets and it's paying off. So you have to look at what exactly you are doing, which one will actually benefit what you are doing before you can actually say, okay, fine, I'm going to go for this particular aspect of protection. Another thing is you could have copyright and also have trademark. Recently, Disney trademark, Disney copyright is going to expire next year. So we're like, okay, fine. Even if the copyright expires next year, they still have trademark to keep them going. So they have all of those things like, okay, if this one goes, then one is still available. So don't just look at only one trademark right, because you can actually go sideways. You can have a product that have all the 4 types of intellectual property. So it depends on what your client wants at that moment. Priority. The priority matters. The priority could be trademark rather than copyright. So do the trademark first, then come back for copyright. Thank you.
Thank you, Amusa. That's actually very enlightening. It's really, but if I may ask a quick question. Okay, let's start with the question. But let me ask this question. Underline question, yes. The issue of the Coca-Cola bottle, that you're saying that protecting it, you can either use trademark or industrial design. So I'm trying to look, how do we protect the bottle using trademark? You know, the bottle is basically the shape. So how do you protect that using trademark?
Okay, so now the bottle is the shape, right?
Exactly.
But the bottle is kind of three-dimensional. If you look at trademark protect three-dimensional design. So from that bottle, you can see the top, you can see the side, and you can see the bottom. So that's a three-dimensional design. I'll give you another example. Toblerone, that chocolate, triangle chocolate, is protected on that trademark. So you can either go for trademark or go for industrial design. But because trademark lasts longer, it's advisable to go for trademark. Except if you're in a very competitive industry, like furniture. You know that, okay, if I do furniture, within 5 years, somebody else will come up with another furniture design. You can now go for industrial design. So it depends on how you want to last in the market. Like Coca-Cola, they don't intend to even bring out another bottle. I don't think so. So they are still enjoying their rights of that bottle. So why do they have to protect another one again? So I think that's how it works.
Thank you very much. So let me just start with the question from you. So we have a question here. The question says, who owns the intellectual property of the music track? Who owns the IP of the music track? The record label or the artist?
Okay, so when it comes to music, like the music industry is very critical and it's very dicey. So when it comes to music, we have the music composition and the sound recording. Now, the sound recording is composed of the sound, like the one we hear the artist sing, that's the sound recording. So while the musical composition is the lyrics, the beats, the whatever they've contributed to it. So now that music recording now belongs to whoever contributed to it. Do you get? So when you talk about this one, the record label or the artist, it could be the record label, it could be the artist. So if you're not signed under a record label, then it will belong to the artist. But if you are signed under a record label, most of the rights will actually go to the record label. Except you have a contract that says the rights will belong to both the record label and the artist.
Thank you very much. I think that is actually very direct. If you are under a record label, it belongs to the record label most time, except there is an express contract. Otherwise, if you are on your own with no record label, it belongs to the artist. I think that's correct. Thank you very much. So let me direct the next question to Juliana Imon. So the question said, can an individual sue for a song not fully copyrighted? A song that is not fully copyrighted, can you as an individual sue for it?
Please let me know if you can hear me. Can you hear me?
Yes, we can.
Yes, we can hear you.
Hello, please let me know if
Hello, yes, we can hear you. We
can hear you.
Can you hear me, sorry?
Yes,
ma, we can hear you.
Okay.
Can hear you.
Okay, I think
we lost her.
I think she has me, yes.
Okay.
Maybe she just wants to address it. Yes. Hello?
I think she's back.
Yes, we can hear you now. You're back. We can hear you now.
Okay. So what I wanted to just add to the first question is that the owner of a musical work, so Shukura already said it, that they're divided into two. There's the composition side and then there's the sound recording side. So for the sound recording, it's majorly the person that made the payment for the work. So if it's the record label that made the payment for the sound recording, then they would most likely own it. If it's the artist that made the payments, then the artist would most likely own it. If it's the producer, because we also see where producers fund sound recordings. So if it's the producer, then the producer would most likely own it. But it's always good to have a contract that speaks to that, so that even if the record label made the payment for it or the producer, let there be a reversionary clause. So the reversion clause might say, okay, after the next 20 years, then it will revert back. For example, if you listen to Kanye West, he was talking to his record label that they should tell him how much his sound recording costs so that he can pay for it. So it's good for you to look at the contract to know if there is a clause where you can buy back your master recording or if it can revert back to you. And then for the composition side, that's the reason why we need split sheet agreements. So the split sheet agreement will state how many percent everyone who made a contribution in the work owns. So if the composition, for example, the producer that made the beat and all those things might take 20%, then if there are multiple songwriters, they can also share the different percentages. So it's good for you to have a split sheet agreement that would speak to the copyright ownership in the composition side, and also a contract that would talk about the sound recording part. Yes, so thank you.
Thank you very much. I think that clears it more. Thank you very much for that. Yeah, so the next question actually will be direct to you. The question says, can an individual sue for a song not fully copyrighted? So basically, a song that is not fully copyrighted, can an individual sue for it?
Okay, so when you say fully copyrighted, it doesn't really make sense, because if you create a work and the work is put in a fixed form, then you already have copyright to the work, whether you register it or not. However, people are advised to notify or to register, whichever is applicable in their jurisdiction. So if you have the copyright to your work and anybody uses your work without your permission, then they would be infringing your rights. So I think it's as simple as that. However, there is like the fair use concept, but even with that, at least you should be told about it. And then there is the compulsory license, voluntary license, and all those things. So the more you study this area, the more you understand how to license your work and the different types of licenses that are applicable.
Yes, thank you. Thank you. It's that simple. Once you create your work, it is automatically copyrighted. So yes, in a related question, but I would direct this to Amusa. The question says, if an individual's copyright expires and it hasn't been renewed, can anyone use such product that has been formally copyrighted? If an individual's copyright expires and it hasn't been renewed, can anyone use such product that has been formally copyrighted? So that's the question. A copyright expired. Can someone else use it?
Okay. So I think Juliana mentioned this previously. Like there's nothing like renewal of copyright. So copyright generally in musical and artistic work, literary and artistic work lasts for throughout the lifetime of the author, and 50 years or 70 years. In Nigeria, it is 70 years. Some other jurisdiction is 50 years after the death of the author. But for works like photography, choreography, cinematography, sound recording, they are all 50 years from the date it was recorded, or from the following year it was recorded. So the thing is, once your copyright expires, it expires and it goes to the public domain. So the thing is, before it expires, it takes a while, like throughout the death of the author, throughout the author's life, and 50, 70 years after the death, that's like as if it's not going to expire at all. Do you understand? So look at Michael Jackson now and Fela, they are still benefiting from their work, because quite all right, they are dead, but they still have like 70 years after their death to enjoy all of these things. So once the work has expired, it has expired. There's no renewal. And once it expires, what happens is it goes to the public domain. Public domain means that just the marketplace where everybody can just go and just pick whatever you want to use. There's no infringement. As long as it has expired, there is no infringement. You're not infringing on anybody's rights so long it has expired. The same applies to patents. Once your 20 years is over, it's in the public domain. Anybody can pick it and use it. So the only rights that you can refer to now will be moral rights, not economic right now. Moral rights, which has to do with your attribution rights, your paternity rights, your publicity rights, and your right to like attribution, your paternity right to use the product in a bad manner or in a way that you don't like, but not the economic rights this time around.
Okay, thank you very much. I think that is something too. In short, copyright, once it expired, it can be renewed. It has expired. And yeah, it has expired. That's basically the short answer. So after it expires, anybody can use it. It's already in public domain. So yeah, the next question, I'm writing it as Juliana. The question said, if one or more people coincidentally make similar creatives, what will be done? More than one person create similar creatives coincidentally at the same time, what will be done?
Okay, so for example, for the copyright protects the expression in a work, not the idea itself, meaning that I can write a story about how Buhari met Aisha, and maybe they met in the workplace. He was an army and she was the nurse. You can write about it and say they met in the hospital or they met somewhere else. So you can have similar storylines. What copyright is protecting is the expression. However, if the expressions now look as if you people copied each other, for example, now, if maybe I did a work, released it today, you released your work tomorrow, and there are some lines or like some paragraph that are exactly alike, then you know that one person copied the other person. So then there will be an infringement. But if it's just you expressing yourself in your own way and me expressing myself in my own way, then there is no infringement in that. But let us also note that most of these IP protections are territorial too. So if it's like a trademark or something, you might have something in the US and I'll have something here in Nigeria that have the same names. But because it's territorial, I'm not infringing on their right, they're not infringing on my right. However, if they want to come and do business here, then they would have to get a license from me or they'll have to buy the trademark from me to not be infringing on my work. So you just have to understand the way IP works and what is for what. For example, copyright is not necessarily territorial. So if you do a song here, somebody copies it in the US, they are still bound by the Berne Convention. But if it's a trademark, patent, industrial design, etc., they are not bound because it's territorial. So it's just to understand which of the IP is territorial and which is not. Thank you.
Thank you very much.
I would like to add to Juliana Imam's response. So based on the idea, so I was at a conference and a guy was like telling the story. They were supposed to like present maybe a design or so. So unfortunately for him, he presented a similar design with somebody else. Nobody copied, but they just happened to come about the same. They expressed their design in a very similar way, and you couldn't tell who copied who. So in this situation, let's assume one of them actually copyrighted, like registered with NCC. You have the opportunity to say, okay, fine, I registered, I have a certificate to show for it. So, and you might get that ownership instead of the other person. So this is where copyright registration comes in. You have something to show for it that says, I registered this before this person. So there's possibility that this person have seen my work somewhere and copied it. But in a case whereby you didn't register it, so how do we know who did this work first? I hope that helps.
Thank you very much for the addition, Amusa. So I think in short, the answer is that two things attach: the territory and the first to register. So the first question you ask is, are they in the same territory? If they are not, then they are free. But if they are in the same territory, who first register who first copyright or register with the NCC among the two committees? So I think that answers our question on that. Then the next question, I'll be directing it at, yes, Hamusa. It said, okay, can a copyright be transferred or willed from an individual to another? A copyright, yes, can it be transferred? Yes.
Okay. So even when we say intellectual property are intangible assets, the same right that occurs, that applies to tangible assets, applies to your intangible assets. It can be willed, it can be transferred. You can use it as collateral, you can use it to get loan. It's the same, it applies the same way, just that one is intangible, while one is tangible. So yes, you can transfer your copyright, you can will it to your children or to your grandchildren, to anybody you like. So you just have to like go to the Copyright Commission and let them know that, okay, probably there's been a change of ownership. I want to add this person to the ownership. So when I'm no more, this person can take over and all of that. Yep.
Okay. Thank you. Any addition? Okay. Will it be right to add that we should also know that it is only the economic rights that can be transferred?
Yeah, exactly. Not the moral rights. Yeah,
it's only your economic rights. Your moral right is yours. So yes, the next question. This will be for Juliana. It said, let me see. Okay, the question said, how do we mitigate disputes arising between different jurisprudence, transboundary of industrial property rights protection? Let me try to read that again. How do we mitigate disputes arising between different jurisprudence, transboundary, basically of industrial property rights protection? Basically, dispute between two, should we say two territory? I hope I'm correct. Dispute between two territory in relation to industrial property rights. I don't know if you get my question right.
Yes, I get your question. Thank you very much. So I think it's disputes between people in different jurisdictions. Yes, so yes. First of all, if there is a contract, that contract will actually state where what court will handle what courts that they will submit to, and then what law will guide the contracts. So the contracts can guide that. However, there is also the arbitration clause too that might also be stated in the contract. So it's good to go back to the contract and see what the contract says. Or you check for where the subject matter applies. That can also determine the jurisdiction. Then if it is online and maybe, so for example, if it's like e-commerce or if it's music distribution or something that is online, what you can do is, first of all, to send a letter, a cease and desist letter saying, okay, you are infringing on my work and all that. Then after you've said that, if they respond, fine. If they don't respond, you can then write to the body that is hosting whatever they are hosting online so that they can take it down. So if it's your song or your film or something that an illegal site is selling or is hosting, you can write to the people that are hosting it to actually bring that thing down. So that's if it's online. Then there are bodies too that help to resolve disputes. So there is a Center for Dispute Resolution that WIPO has for domain name and for other issues that relate to IP. So if it relates to IP, you can use the WIPO system to address that issue. Then I think there is the domain name, there's the body that's in charge of domain stuff. So they too dispute. So I think that the best thing is to look at the kind of disputes that you have in front of you. If it's something that has already been stated in the contract, then you use the contract to determine what jurisdiction would hear the matter. If it's if there is also the alternative dispute resolution clause, you also look at it to know what it says. Then if there is no contract, then you write to the person and then you move on from there. But if the person is not responding and it's online, then you write to the body to take it down. For example, if you have a song and then someone is, different people are claiming ownership to that song and all that, what most of these bodies would do would actually be to pause the payment of the song. They will just pause it until there is a resolution to the matter before they continue paying. So that is the power in your writing. So you write to the body that is distributing or is paying or whatever and tell them to pause the payment until there is a resolution to that. So even if the person has refused to answer you, once you write to the body and the person stops receiving payment, then the person would actually come to the table to negotiate with you, and then that thing can be resolved, or you go through the WIPO route. Thank you.
Oh, thank you very much. Thank you very much for that deep answer, sincerely. It helps a lot, sincerely. So the next question here, I hope it is clear to everyone, though. So the next question is, the question will be directed to Hamusa, basically. It says, what are the remedies available for infringe or intellectual property for, what are the remedies available for infringement? Okay, infringement of intellectual property rights is this. Okay, sorry. Let me translate the question. Okay, it's saying that what are the remedies available for infringement of intellectual property broadcast rights? I think that's what it's trying to say. Basically, what are the remedies available for infringement of broadcast rights or intellectual property rights? That's it. Sorry, Amusa.
Have general remedy, different remedy for production. The remedy can be general. So the first one we're going to look at is injunction. So injunction is one remedy. Sorry. Injunction is one. Then account for profit. Injunction is when you go to court, the court can ask that person like to stop selling that product. Probably if it's an infringing broadcast program, they'll be asked to stop broadcasting that program throughout for the meantime while the case is settled in court. Then you can also account for profit. Account is like that broadcasting station will be asked to account for how much they've made off that infringing item. That's account for profit. Then you can also look at cease and desist. The first thing you can send a cease and desist letter. So if they refuse to attend to you or they refuse to respond back to you, they can now go to court and start doing the injunction and all of that. So we have the injunction, we have the account for profit, we have cease and desist, and which other one? Damages. Damages is another one. So it's just general for probably all infringements. It's not specific to one particular aspect of copyright. It's general.
Okay. Thank you. I think that's actually very clear enough. Thank you for the success answer. The next question, yes, will be directed at Juliana Imam. He said, we understand that comedy is eligible for copyright protection. Now, apart from the stories told to audience in comedy, what other part of comedy can be regarded as intellectual property? So he's just asking that, apart from copyright, what other intellectual property rights are involved or can be, or yes, are basically involved or included in comedy?
Okay, so I would start from copyright, yes, which is the basic one that is needed for comedy, and then trademark. So the person that is giving the comedy has a name, Abi. for example, La Sisi. So that name can be trademarked. Then if there is a particular slogan, for example, I think that the slogan that is usually used by, there's a particular comedian, but I don't listen to him, but I think my husband listens to him, that had like a slogan that Peak used or another brand used. And then he sued for it because he had a, yes, because he had actually done a trademark registration for. Yes, yes, yes. That's it. So you can also protect the slogan. So, for example, I think Real Worry Pikin, she has a particular slogan that she says before she says all her jokes, and she says after she says her jokes. So she's supposed to go and do a trademark registration for that slogan, so that if any brand wants to use it or anybody wants to use it before their comedy stuff and all that, they would actually be infringing on her stuff. She can also use it for merchandising and all that. So there's people that maybe when they are having their shows, they do like merchandising and all that. So they have to go and do that trademark. Then if you have a logo too, for example, I think Shaggy has a logo that he uses something like this when he stands and he do one thing like that. Yeah. So that's his logo. Yeah. So that logo now has to be trademarked for you to enjoy that protection. That can also fall under copyright too. You can also do it maybe as an artistic work and all that. Then if, for example, there is a way you do your own, there is a kind of set that you do that is unique to you, you can also see how you can protect that set, the colors and all that. So you just have to look at all. Then if there are trade secrets to something that is unique to what you're doing, then you also feel free to make sure that everybody that is working with you, that is in your crew, signs the agreement to protect that trade secret. So it's good that you look at all the protections: trade secret, copyright, industrial design, trademark, everything that is available. Make sure that if it is something that you can use it, so that even if it will overlap, if anybody come from this side, you can sue them. If they come from this side, you can sue them. Yes. So I think that's like my answer.
Yes, thank you very much. Thank you. But I think that's actually a very clear answer. I hope we are all clear on that. Any addition from Amusa?
No, that's all. She has done a good job.
Thank you. So the next question directed to Amusa, it said, what is more important way innovators or engineers can stop people from counterfeiting? Basically, how can innovators or engineers stop counterfeiting using IP strategies?
Well, the truth is, we actually can't stop counterfeiting. Like, we can to some extent, but we can't stop it entirely. Because most, or one of those things that actually causes counterfeiting is when a product is being sold at an higher price. So these people that buy the counterfeited one are those that can't afford that original product. It's just like selling for a different market. The original product is for those that can buy the higher price, while the counterfeiting one is for those that can't afford to buy the main product. So we really can't, I don't think there's a way we can actually stop it entirely, but maybe these inventors, they can try to create their products in based on the market. You can create one for your main market people, your main audience. You can create an intermediate one for the intermediate audience and create a lower one for the lower audience. So everybody can buy the one that is affordable based on their pockets. I think that would be a good one.
Thank you very much, Amosa. I think I would also add that if you have the money and you are open to working with some of these agencies, you can also work with them, but you will have to pay for their services most times. However, I know that there are some times that they go and they raid and all those things. But if you specifically want their service, maybe you want to work with the police, you want to work with the customs, you want them to be checking ports for your work, you want them to go and raid the market on your behalf to check for pirated goods and all those things, or counterfeited goods, etc. You might have to pay extra for that service. The reason for this is that for intellectual property, you are the police of your work. So it's not something that the government will be doing on your behalf. But for you to carry out that service, even if it's online, there are still some people, there are still some bodies online too that help to track some of all these pirated and counterfeited and all these fake and illegal things. Same with physically too. You might need to pay them for that service. So some people that have the money actually do it. Thank you.
Thank you very much for the addition. So basically, you fight for your rights. You protect your invention. That's what you're saying. That's actually it. That's the, I think, well, that is it, yeah. Then the next question says, to Juliana, it says, when an innovator's IP rights are infringed upon, is there a set down amount of compensation to be paid, or the innovator decides? If the innovator decides and his request is unfair or unreasonable, what's next? Basically, it's saying that when it comes to infringement of innovators' rights, is there any set down rules on how to decide the compensation? Basically, is there any set down rule to decide the compensation to be paid to the innovator? Who decides? The innovator, or is there a rule? So basically, that's the question. How do we decide the compensation for the innovator's IP rights?
Okay, so for the compensation, if you take the infringement to court, then it's the judge that will decide what the compensation will be. If both of you decide to go through arbitration, then the arbitrators will decide. If it's a mediation, then both of you will settle on how much should be paid for the infringement. So it depends on where you submit to. So that will determine what the compensation will be. However, there are sometimes that infringements happen and then the people come to meet you, or you find out and then you meet them, and then they are now saying, how much do you want us to pay for us to continue using this? Well, at that point, some people might be reasonable. That means they are now trying to negotiate a licensing fee. So there is a compulsory license, and then there's also voluntary license. So, for example, some of these pharmaceuticals, and even in the music industry, there is the compulsory license. So if a compulsory license is put for something, then that means there's a fixed amount that will be paid. However, when it's a voluntary license, the owner of the work has the sole discretion to determine what they want to charge for the license. So if you initially infringed on a work and maybe you don't want the bad publicity and all those things, and now you're coming to them to ask for license, if it falls under a compulsory license, that means there's already a specified amount that should be paid. So you just pay that and then it covers it. That's for that's for compulsory license. But if it falls under voluntary license, then it's the owner of the work that will put any amount that they think is the value of their work. And then you can either decide to pay, or if you cannot pay, they can then take you to court and then the judge will now decide. Thank you.
Thank you very much for that. I think that was all about the question. But before we conclude, there are two questions that pop up, which I don't know if you can quickly address them. One, someone said, okay, you are discussing about the fact that if two creatives coincidentally invent or create two things at the same time. Someone said, what if they both registered at the same time? What if somehow they were able to register the creations at the same time? What happened?
That is why I'm saying that copyright protects expression, not the idea. So even if the idea is similar, what copyright is protecting is the expression that is put in a fixed form. That's the reason why you have different storylines on Cinderella. You have different storylines on Romeo and Juliet. There are different expressions of it. So once you have two different expressions under copyright, you can go ahead to protect your work, and it doesn't matter. Where there is an issue is when you can prove that one person copied from the other person. For example, if I write a book on Get Rich in 5 days, and you too, you write a book on Get Rich in 5 days, and there are two different things, because two of us can write on the same topic, but we'll write about it in different ways. But if you now carry my book, and as you're reading word for word, which is saying, the way I made my money in 5 days, I first sat down, I drew from this, and you open the other book and it's saying exactly the same thing. Then two of them would then have to go to court and determine who wrote what first and who copied the other one and who has access to the other person's work. But if it's different and you cannot see that paragraphs were dubbed and all those plagiarism issues, then it's just protecting different expressions, which is not infringing on the other person's work. But if it's other types of protections like trademark, industrial design, etc., before they are protected, there is always a search that is carried out. So that search that is carried out is supposed to determine whether there's already a pre-existing work. If it's a patent, there's a prior art search. If it's a trademark, there is a search. If it's an industrial design, there's a search. But for copyright, they don't conduct search for copyright. So if you come, you just do your registrations and you move. What they are protecting are the expressions, not the idea itself. That's why different people can write on the same topic, but the expressions might be different. But where is the same, you can then decide to go to court to settle the matter. Thank you.
Thank you. Well, I don't know. The other person is saying
I'd like to add to that.
Okay.
Let me add to that. I think what the person was asking was, what if both parties registered the copyright at the same time? The truth is, you can't register at the same time. One person will always come first. It could be in seconds, it could be in minutes, it could be. So the first person that first registered owns the rights.
Okay. Thank you. I think that solves it too. So first is that are they doing the same thing? If they are the same, there is always the rule of the first register. We still proceed. So there's only way to decide that. So I think that's all. There is one that said, can passion be patented? Passion, can it be patented? Amsa, please can you help us with that one?
When you say fashion, like fashion is diverse. What aspect of fashion? So Crocs is fashionable as well. And Crocs has these breathable shoes. They have a patent for breathable shoes.
Okay.
So it can be patented as effect to that invention, then it can be protected.
Okay. Thank you. So
okay, I think
any other question should be done.
Raise his hands, so you can ask him to ask his question.
Who is that?
Tijani Salahuddin. I can see.
Okay.
He raised his hand.
Okay, Tijani Salahuddin. Can talk, please?
All right, thank you, sir. So good evening, ma. My question is, I would actually like both of you to answer, ma. So my question is, there's something they call related right, and maybe I do not get the concept of related right, but what I know about it is that it deals with I don't know, this like a it use okay, for instance, somebody made a video of a song. Maybe what protect that video is related right. Basically, what I want to say is that there's a guy recently that made a video. His name is Blackbone. So he made a video and then he includes all other person's videos today. So I was not thinking, okay, has he not infringed on other person's rights too by making he compiled different person's video and made it as one? Is that an invention or he has infringed on their right? I don't know if you get what I'm trying to say, man. Or should I try and explain better?
I understand. I understand the question, and I saw the video as well. So first off, when you say related rights, that's not how related right works. Related right is a right neighboring on copyright. It's just like a part of copyright, but not entirely copyright. So what related right does is there are some aspects that are not covered by copyright. So those aspects now are covered by related rights. For example, broadcasters, producers, and broadcasters produce three, broadcasters, producers, and performers. So those three rights are not covered under copyright, but they are protected under related rights. So that's how related right works. So I know all of us just categorize it as copyright actually, because it's still a part of copyright, but not really related. Broadcasters now, not broadcasting, broadcasters, producers, and performers, they are protected under related rights. Related rights and copyright are all copyright, so we all call them copyrights majorly. But to answer your question on the Black Bones thing, now when you look at what Black Bones did, yes, I understand that he came up with some aspect of Ashake. He was using the golden teeth and he wrote something on his neck, and some part of Arista and some other people. Now, basically, we can say it's parody, because it's as if he was making jest of them during the video, and the aspect of Oxlade as well. So it's not as if I understand you feel like it's copying them, but it's copying them in a way that to probably make jest of them, or just say that, oh, this is how this person used to do his own video, or this is how this person looked like while doing his own video. So to some extent, we can say it's parody, whereby parody falls under fair use. So fair use, we have education, parody, news reporting, and some other aspect of fair use. So if it is not, and again, the aspect, and that thing is nice, is making money from it. That's another aspect. Normally, you are not meant to actually commercialize a work that is fair use. But like we all know, copyrights can be so very dicey. We can also conclude that, okay, fine, because Black Bones has taken a part of this one, it has brought them together. There is now a creative aspect to what he has done. And we can now say he has transformed the work. So the work is now transformative and now enjoys copyright on its own. Find a solution or conclude on something on that particular video. I hope that answers your question.
Yes, very much. It does. Thank you very much, ma.
Right,
but I have one last question, ma.
Okay.
All right. My question is, you were saying something about copyright that after like 70 years after the death of the author, it expires. My question is, okay, what if the author dies and after his death, immediately after his death, then someone infringed on that right? Who will sue on his behalf since he's dead?
His family members.
Oh, they
call it, once you are dead, they call your right estate. Let's say you have an estate. So his family members will come after you. So like Fela now, people that collect money on his behalf are his family members. So we say the money goes to his estate. That's what they call it.
Okay. Are you clear with that?
Yes, I think two other people raised their hand. If you can still take their questions before we end the session today.
Let me check them out.
Miriam and Philip.
Miriam.
Yes.
Miriam, are you available?
Okay. Yes, I'm available. Thank you very much. My question is directed to Mrs. Amosa. She said that she can use an IP right. So, for example, let's say you give your copyright to another person. When life expectancy starts, it's like from when the original right was registered or the beneficiary. That's my question.
Yeah, from when the original right started counting. So you won't say because you've transferred the right to somebody else, you have another date counting from that time. No, you start counting from when it was actually protected.
Yes, I think Philip already sent his question too. He said, who has ownership over a picture or photo shoot snapped by a photographer? Is it the photographer or the client who paid for it? Basically, who has ownership over a picture?
Okay. So the discussion around this photographer and the owner and the model and the celebrity is quite a broad one. You can check my LinkedIn page, Amosa Shukrat, or you check my Instagram page, The Intangible Nuggets. Like, it's well explained, but I'm going to address it briefly. So basically, like we know, the copyright to a photograph work belongs to the photographer. However, there are some instances whereby you hire the photographer to work for you. In that case, then it becomes a work for hire. So if you're hiring the work for hire, if you're hiring a photographer rather, there should be an agreement in your contract that says, okay, I'm hiring you to do this work. So directly or indirectly, you will be transferring your rights to this work to me. So this means that you won't have any rights in this work. Everything will be transferred to me. The only right you have is your moral rights, not your economic rights. So if they have that kind of contract, then the right belongs to the person that hired the photographer. But in the absence of this kind of agreement, the right belongs to the photographer and not the person. I hope that answers the question.
Yes, Miriam.
Sure.
Yes, ma'am. Thank you very much.
Okay. Okay, so I think that would be the end for now. I don't think we have any question again. So that's actually all. That's all. So thank you. If Juliana, do you have anything to us to say before we end the session?
Thank you, everyone. Thank you for making this session interesting. Thank you, Amosa. Thank you so much for the knowledge and the positive energy that you always bring to wherever you are. Thank you so much. Thank you, Nifemi. Thank you, Hussein. Thank you to all the mentees that presented. And for the group that did not present, please try to present next time. So with that, we've come to the end of the session for today. Thank you, everyone. Have an amazing weekend. Please rest properly. You'll be receiving your presentation topics and your groupings shortly. Thank you all. Bye.
Okay.
Bye. Thank everybody. Bye-bye.
Bye, everyone.